Today, we're jumping into a really fascinating legal puzzle that sits at the heart of every single criminal case in India: jurisdiction. With India's new criminal procedure code, the Bharatiya Nagarik Suraksha Sanhita, or BNSS, the rulebook for deciding where a crime gets tried has been given a major update. Now, I know it sounds technical, but honestly, think of it like drawing a map for the justice system. So let's figure out how to read it together. Okay, let's dive right in with a scenario that could be ripped straight from today's headlines: a phishing scam. You've got the scammer in one city, the victim in another, and the money trails zipping through a server in a third city. It's a mess, right? So which court actually gets to handle the case? Stick with me, because by the end of this, you'll know the answer.
All right, before we get tangled up in those complex cases that cross state lines, we gotta start with the foundation. For most crimes, there's one simple, straightforward rule that decides everything. Let's call it the golden rule of jurisdiction. So this is all laid out in Section 197 of the BNSS, and it's about as simple as it gets. The trial happens where the crime happened. A theft in Kanpur, it gets tried by a court in Kanpur. It's clean, it's logical. But what happens when the crime itself isn't so neat and tidy?
This is where the puzzle gets really interesting. You see, crimes aren't always contained within nice, clean lines on a map. They can spill across city limits, state lines, and these days, even digital borders. So, what do you do when the location itself becomes a big question mark? I mean, just think about it. What if a crime scene is literally on the border between two different court districts? Or what if an action starts in one place, but the real damage, the consequence, happens somewhere else entirely? The law absolutely needs a clear answer for these messy, real-world situations. And you know what? The law's answer is actually pretty smart. It's all about flexibility. If it's genuinely unclear which side of a border a crime took place on, then either court can take the case. The exact same logic applies when an act and its consequence are separated by distance. Say a shot is fired in one jurisdiction, but the victim tragically dies in another. Well, the case can be tried where the shot was fired or where the ultimate consequence happened. This flexibility is so important because it's designed to make it easier for victims to get justice, not harder. And this idea extends to crimes that happen in different stages. Let's say a criminal conspiracy is hatched in City A, but the actual crime goes down in City B. The BNSS is crystal clear on this. The trial can happen where the plan was made or where the action took place. It links all the pieces of the crime together, so criminals can't just use geography to try and escape the law. Now let's shift gears and look at crimes that are literally in motion. Not all offenses happen in one fixed spot. Some happen during a journey or unfold over a huge distance. Okay, check out this classic example. A person gets on a train in Allahabad, and as the train is passing through Kanpur, their wallet gets stolen. The train keeps going through Etawah and Aligarh before they finally get off in Delhi. So, where can they file the case? Well, according to the law, the trial can be held in any jurisdiction the train passed through after the theft happened. That means Kanpur, Etawah, Aligarh, even Delhi. They're all fair game.
This principle is especially vital for what the law calls continuing offenses, and kidnapping is a perfect example. See, the crime isn't just a single moment in time. It's ongoing for as long as the person is being held. Because of that, jurisdiction basically follows the victim's path. A case can be tried where the abduction started, in any place the victim was moved through, or where they were finally hidden or detained.
And of course, this same logic applies to our modern digital world. For crimes committed through electronic communication, we're talking emails, instant messages, you name it, the law is beautifully simple and powerful. The case can be tried where the message was sent or where it was received. This is an absolutely critical rule for tackling things like cybercrime and online harassment. Okay, so the law provides a whole lot of options, which is great for victims. But that flexibility can sometimes lead to a brand new problem. What happens when two different courts both think they have the right to hear the same case? Who gets to step in and be the referee? And this is a real-world issue, not just a hypothetical. You could easily have a situation where a court in one state and a court in another both kick off proceedings based on the same set of facts. You can see how that could lead to total chaos and legal gridlock if there wasn't a clear system to sort it all out. And luckily, the system for resolving this is actually pretty logical. It all starts with one question. Are the competing courts under the authority of the same high court? If the answer is yes, then that high court just decides which local court is going to handle the case. Simple. But if the courts are in different states, then it comes down to a simple tiebreaker. The high court in the state where the case was first filed gets to make the final call. So, we've walked through all the key pieces of this jurisdictional puzzle. Now let's put them all together, solve that problem from the beginning, and really understand why this legal map is so incredibly important. All right, let's go all the way back to our phishing scam. The scammers in City A, the victims in City B, and the servers in City C. Where can the case be tried? Well, based on the rules we just covered, it can be tried in any of those places. City A is where the criminal act started. City B is where the consequence, the deception, was actually felt by the victim. And you can argue that City C, where the server is where another part of the act or its financial consequence happened. The bottom line is, the law gives the victim and the police multiple options to go after the criminal. You know, at the end of the day, these rules are so much more than just dry legal theory. They are practical, powerful tools. They make sure victims aren't denied justice just because a crime was complicated. They give police and prosecutors a clear roadmap, which prevents confusion and delays. And most importantly, they show how our legal system is really trying to keep pace with the reality of modern, often borderless crime. This legal framework is a huge step forward, no doubt. But it does leave us with one final big thought. As crime gets even more global and digital, what happens when City A, B, and C are in 3 different countries? Redrawing this map for international crime? Well, that's the next great puzzle the law is going to have to solve. Thanks for joining us.